It's a great pleasure for me to be here. My name is David Wilkins. I'm a professor at the law school. I'm so excited to be here at this panel because at this panel we have three of India's leading lawyers, and we have many more in the room who are really living through this transformation of the Indian legal profession in the age of globalization. And in particular, what is the relationship between the Indian legal profession and legal professions around the world and the global market for legal services? My job on this panel is to kind of give a few overview statements around the issues we're going to talk about, and then really to allow the three spectacular panelists who I will introduce in a moment to say some words on these issues, but eventually to foster a dialogue with all of you. There are many people in this room who know as much as our panelists on this subject, and for many of you who are students, this is something of great interest to you, because this is a subject that's really going to affect the development of your career. So let me just say a few framing remarks first. So the GLEE project really starts from this proposition. If you look at India or China or Brazil or South Africa, Nigeria, several other places around the world, the states in the Gulf, that at some point, roughly in the 1990s, in India it's 1991, the countries decided to open their markets to the world, to go from a kind of a totally state-controlled, relatively closed economy to one that's more or less open to the world. And the more or less is obviously a lot about what we're going to talk about here today. Once you do that, that resulted in two things, which we see in India quite clearly. Foreign direct investment and an increasing interest in foreign capital, foreign companies in the domestic Indian market, and privatization of many state-owned assets. Once you have that, it doesn't take long before it's clear that you need new laws to be able to govern these relationships. So you need a securities law, you need an investment law, you need trade law, you need competition law, you may need a reform of the basic corporate law. You need a number of new legal structures, both to regulate the domestic economy, but also to interface between the domestic economy and the world economy that you are more and more connected with. We clearly see that happening in India. It doesn't take long to realize that once you develop a new legal structure, you need new lawyers, or at least lawyers with new kinds of skills. Lawyers who have the skill and the understanding of these new legal structures and can interface between the domestic legal structures and the global legal structures. That's what the GLEE project is studying. It starts with the most visible manifestation of these new structures, which is the development of a kind of new and increasingly differentiated corporate sector of the bar. So, the development of increasingly large and sophisticated law firms, the growth of in-house legal departments, which didn't exist almost at all in many, even the largest and most sophisticated Indian companies. Once you have that developed, then there's a question of how that sector is interfacing with the rest of the Indian bar. So how is it affecting, for example, the advocates? How is it affecting legal education? How is it affecting the development of the kind of administrative apparatus, the legal apparatus inside India? And then how is it interacting with the global marketplace, which of course has to do with the number of multinational firms, often based in the US or the UK, but other places as well, seeking to serve the Indian market. How is it affecting India's ability to operate, for example, in the institutions of global governance, like the WTO, for example? The GLEE project is really trying to understand all of these dynamics, and that's what those 19 studies are about. But at the heart of this is really a conflict over how much of this it will be governed and controlled in India through Indian legal sources, and how much of it will be a part of the global marketplace. And that's really what brings us to the panel today. And this issue, which is often called liberalization, and we'll ask actually the panelists whether they like that as a way of understanding it, has to do specifically with whether foreign lawyers or foreign law firms are allowed to, quote, practice law in India, whatever that means, and we'll ask them what that means. But it's also, I think, a manifestation of a much larger problem, or much larger set of issues, which is what ought to be the relationship between the Indian legal profession and legal professions around the world. And to what extent are those affecting the opportunities of Indian lawyers, both lawyers in existing practices, lawyers who are coming through the system, how is it changing legal education, how is it changing the way in which India is able to operate in the global economy. We have a terrific panel of speakers today, each of whom represents an important lens through which to understand that problem. On my far right is Mr. Rajiv Luthra. As many of you know, he is the founder and managing partner of Luthra & Luthra, one of the most important law firms in all of India, and really an example of exactly what I'm saying, of a law firm that really was kind of created in this post-liberalization period, has grown to be very important in India and increasingly in other parts of the world. Mr. Luthra has also been very active in things like the Society of Indian Law Firms and its formation, as well as in the bar, as well as the United States India Council, and many other parts of this question. Next to him, we have Mr. Nandan Nelivigi, who is the head of White & Case's India practice, which suggests that there are law firms located outside of India that are doing something in India. We'll find out what that is in a moment. He is a product of Harvard, and we're very proud. He's got his LLM from here and has had a very interesting career doing a number of things, both related to India and otherwise, in one of the most important law firms around the world, and certainly in the US, perhaps the most globalized of the U.S. law firms, maybe with the exception of Baker & McKinsey, but certainly one that is really staked out a major global strategy. Next to him, we have Mr. Nakul Dewan. Mr. Nakul Dewan is an independent advocate representing a very important part of the Indian bar. He's a member of Maxwell Chambers in Singapore, which says that it's not just the foreign lawyers from outside of India who are coming into India, but it's also Indian lawyers who are becoming major players around the world. And it's not just in the corporate commercial sector. It's also in the sector of advocates, and therefore he brings a very important lens through which to understand this topic. And as I said, there are many other people around the audience, some of whom, if they don't speak, I will call on them, who I know are really knowledgeable about this set of issues. I'd like to start with Rajiv. I promised him that I would pick on him first because, as many of you know, he is a very shy and retiring personality. If you don't get him to talk, he might not say a word. But Rajiv, you've really have a very unique lens through which to understand this problem. And I'd like you to start first just by saying, for the few, maybe 2 or 3 people who don't know you already, a little bit about yourself and about your firm, and then maybe if you could say a little bit about how you see this set of issues unfolding.
Thank you, Professor Wilkins. I'm going to call him David from now on, because if our Prime Minister can call Barack Obama Barack, I need to say.
Did you see what's written in my suit?
I need a microscope. I've been very fortunate, and I've learned a lot from David over the years. So therefore it means 2 things. One is a large part of my so-called success is because of David. but all my failures are also because of him. So if there's an issue you guys have with me, talk to him. On the liberalization, this has been a kind of a topic which has gone on for about 15, 18 years, and at different levels, and fortunately or unfortunately I've been involved at the possibly the highest level under GATS. There's a committee being formed for Indo-US, and which is JETCO is the one between India and UK, and I chair both committees. And I've been involved with it. So I know the whole process, what's been happening, how it's been happening. I've had meetings with the various stakeholders, the junior bar, the users of legal services, etc., etc. Of course, I wear the hat of a majority shareholder of a law firm. But with that hat, obviously, I don't want anybody else to come in. I'd like to keep my turf protected. Who wants competition? We got free. Nobody wants that. But unfortunately or fortunately, like I said, I also wear various hats. And I have to, as the chairperson of that committee, I have to make sure that all the stakeholders is very well balanced. So in 2006, we wrote out our report, which was made public, unfortunately, by the British, in spite of the fact that it was a clear understanding that it will not be made public. It was made public. There we recommended the opening up of the Indian legal market, but with a few caveats and a few processes which we redrafted and said what acts should change, what laws should change, what should happen. All of that clearly laid out, and the path to opening is there, 2006. We haven't heard a word since. So there we are, and this whole topic has been regurgitated with Obama's visit to India, and they wanted to relook at it again. The ministry again got into the act, and this whole process is going back and forth. My personal view is that because India is a signatory to GATS, we've committed as a nation to liberalize our services, and this is one of the areas which we have to liberalize. How we do it, what conditions we do it, is up to each member country. But the principle is that we as a country have already committed to liberalization, or shall we say reform. Liberalization nowadays has become a bad word. So legal reform sounds much better. So having said that, there are various other things that we need to also consider. One is reciprocity. Now, if we open up the Indian market for, say, American lawyers, then we should have exactly, it's also enshrined in our Advocates Act, by the way, we should have exactly the same facility in America. Now, I wonder, in America, we have, I think, 28 states that don't allow between state practices. So I think America should globalize before they talk about globalization of legal services in the rest of the world. But that, having said that, also if you look at the whole EU structure, now in UK and India are discussing for the last 10, 11 years now, how to open up the services. But what happens when England and India sign? Does the EU get involved? Not involved? How does it work? Not clear. First day of the meeting I said that, till today I've not got clarity. So that's where we are. The way I thought we could do this, you want me to say something about myself, not much to say. I started my life in my father's accountancy practice, and I hope there are no accountants here, and don't quote me on it, but I found that a brain dead type of work, especially auditing, I couldn't handle it. So for about, but you know how it is with father and son. My father was a lovely man, unfortunately passed away 3 years ago, almost to the day. He said, well, son, you do what you want to do. So I started a tax practice. I enjoyed that much more. So 2 things I want to put on the table. One is I've never had a boss. Nobody's ever. I've always been the managing partner from day one. So that's a flaw or a gain. So second is, I don't have that much of knowledge, therefore I'm not restricted. So my mind is fairly open in terms of, especially in the legal field, especially what Prof was saying about things changing and newer skills required. I was a virgin country for that. So that worked out well, and I founded the firm in 89, 90. Literally had a motorcycle with no godfather, no godmother, no slight meant on people who were children and son-in-laws of Chief Justices of India. No slight meant on Attorney General's children, but no slight. But so we started it. It was clearly a glass ceiling, and in India the profession is very closed. So my strategy really was to be a one-eyed man amongst blind men. So I would try and see or look into the future and see where the practice of law is going. Very exciting times. A lot of newspapers and magazines have written about what a great visionary I was. I was the only guy who set up a pure business law firm in India. Actually, if I can say bullshit. Okay, bullshit. That's the only thing I knew. I was not a litigator. I'd done only practice in the ITAT. I did not know anything else. This is the stuff I knew, so therefore that's what we built. And the market opened up at the right time. And I started learning, in fact, from Nandan's former boss, Gene Goodwillie, was my co-counsel in two major infrastructure projects. I learned all my project finance from his boss. And he would come to Bhopal. We'd spend 3 months with rotary phones, so there was no internet, was nothing else. And I sucked all his knowledge in those 90-odd days we worked together. And that's how the firm grew. Now we are close to about 300 lawyers in the firm. And no plug for the firm, not required. We're not allowed to solicit either, but I just thought I'd put that on record. And of course, we are getting next week the National Law Firm the award as well in Hong Kong, but no plug for the firm. But I'm happy to be here. I enjoy what I do, and I'd be happy. I'd rather me talking. I'd rather get questions and sort of more sort of inputs from you guys.
Nandan, you also have a very interesting perspective on this, and why don't you give us a few thoughts?
Right. Thank you, Professor Wilkins. It's always a joy and a challenge to be on a panel with Rajiv, and it's even more difficult to follow his act right after he has just delivered that performance. But it's a real pleasure to be here. I'm based in New York as a partner of White & Case and I lead the India practice. So first of all, let me clarify what the India practice is. Just because India appears in any of the sentences that I use doesn't mean that I practice Indian law, to be clear, which goes to the credit of SILF, actually, who have framed this debate in a way that anytime anybody mentions India and law in the same breath, it counts as practice of Indian law to some extent. What we do is focus on cross-border transactions, representing a lot of international companies and investors investing in India, representing a number of Indian companies and lenders who are doing business overseas. We represent a number of international companies in international arbitration matters. Quite often they are not governed by Indian, the issues are not governed by Indian law, sometimes they're governed by Indian law. So that's the basic idea about what we do with respect to India practice. A few words about myself personally. I went to law school in India, graduated as a member of the first graduating class of National Law School of India in 1993, got admitted to the bar in India, and came and did my LLM here at Harvard Law School. And I was one of the students that Professor Wilkins does not remember. In 1994, that's when I graduated. I'm also happy to say that I was a classmate of Vic Khanna, and joined White & Case in '94. And that was around the time that India had just opened up its economy. And my hope was really that I would really learn what it is to be a international corporate lawyer, and then go back to India at the start of the wave of hopefully what would become international deal-making involving India. I was hired for a one-year job at White & Case, and White & Case said, we're thinking about opening an office in India, why don't you stay on for another year? It gives us a little bit more time to set up the infrastructure, we'll set up the kind of office that you want, and I'm just joking, they hadn't gone that far, but they were thinking about an office. They asked me to stay back for another year, and ultimately they did get a permission to open up a liaison office, and it was permitted by the Reserve Bank of India. But it turned out that it was just a liaison office, and I was not interested in going and working in the liaison office. So I decided to stay on over here and continue to assist in a number of matters we were working on at that point of time, and one of which was the matter that Rajiv and I and others in our firm worked together, which was a great learning experience for me, working from New York with lawyers in India and learning along with them. And then White & Case and a number of other law firms got sued in India for having received the permission from Reserve Bank of India to open up an office. And ultimately, the court held that the Reserve Bank of India did not have the power to issue that license. That was the lawyers' collective case. And we closed our office, and we are happily running our cross-border India practice from outside of India. And all the issues started when people started talking about liberalization all over again. So my perspective is not just from the point of view of an international law firm, which is saying we want India to open up the sector to foreign lawyers no matter what. My perspective is of somebody who has grown up in India, come from India in the US, but looking at it from the perspective of a US law firm, as well as from the perspective of an Indian lawyer. And what that means is I do see the issues with regulation of the legal profession in India, even more so than people who have not gone to law school or do not know the Indian legal profession, at least in the US. And that is that the Indian legal profession, the regulation of the Indian legal profession definitely needs reformation, no question about it. And it's for the sake of the Indian lawyers, and the reforms are not for international lawyers. There are international law firms who do want these reforms to take place, but from our perspective, from White & Case perspective, we are not there saying India needs to open up. It's not our call. India needs to decide if this is good for India and the Indian legal profession and all the young lawyers that are coming out of Indian law schools. And if it's really good for India, then we're happy to go look at it and consider whether it makes sense for the law firm. Other law firms may have a different point of view, but first and foremost, the only time I see that people talk about reforming Indian regulation of Indian legal profession is seriously is in the context of liberalization. And so I think the talk about liberalization for foreign lawyers is actually a good thing for Indian lawyers, because that's probably the way these reforms are going to come about. So with that, I'm going to ask Nakul.
Thank you. Nakul, please. You have a very interesting perspective on this, both from being from the advocates bar, but also because you yourself are part of a globalized chamber.
Thank you, Professor. I am the baby in the system, and I am going to spend the least amount of time introducing myself. You know, when I graduated in 2001, I was told that I could join a foreign law firm in 2002. 2002, 3, 4, 5, 6, nothing happened. Finally, I said I had to step out, which is what I did. So I took the first left turn and I moved to Singapore. And then I got called to the Singapore bar, and I started practicing in Singapore with a law firm called Allen & Gledhill, whose managing partner is a great friend of Rajiv Luthra's, a gentleman called Lucian Wong. And 2 years after I got called to the Singapore bar and started going to courts, I went to Lucian Wong and I told him, I want to restart India. And he said, Allen & Gledhill can't go there. And I said, I'm a counsel with your firm. I only appear for your firm. I haven't taken up partnership. I haven't signed the document. I can go to India and set up my own counsel practice again. And he said, go ahead and do it. So in 2011, I went and restarted India. And then in 2014, I took one more left turn. I left Allen & Gledhill, went and joined 20 Essex Street, which is a barrister's chamber in London, got called to the UK bar. So I've taken 3 left turns, which basically means when I take my 4th, I'll be back at square one. But the long and short of my life is this. I practice in India and I go to courts in India. I go to courts in Singapore and I do arbitrations in Singapore. I can go to courts in London and I do arbitrations in London. And my perspective is very simple. If I can sit in India and be an Indian qualified lawyer, and I can go out and practice in 2 different jurisdictions, why should any other Indian lawyer not be able to do it? And if I can do that, why can't I sit in India and give out an English law opinion if English law lets me do it? And why can't I give a Singapore law opinion if Singapore law lets me do it? And why can't I team up with Nandan and both of us set up a law firm and do exactly the same thing because we're both Indian qualified and we're foreign qualified. What stops us from doing it? Now, if nothing stops us from doing it, then where is there a bar? And the bar, as Nandan pointed out, actually comes from a decision of the Bombay High Court in Lawyers Collective. And what was Lawyers Collective? Were Lawyers Collective commercial lawyers? The answer is no, they were not. They're not. It's a public interest it's a non-government organization. They don't understand commercial law. They don't understand commercial realities. And what is a law firm? And it's a question which I will put to the people sitting here as well as to people sitting with me. Is a law firm registered in India? The answer is no. Every lawyer is regulated individually. A law firm is nothing else but a collection and pool of lawyers. So if a law firm is nothing else but a collection and a pool of lawyers, why can't Nandan and I set up White in Case India? If I'm Indian qualified and so is he, we are both regulated by the Indian bar for any Indian law work that we do. We're both regulated, he's regulated by the New York bar, I'd be regulated by the English bar for any other foreign law opinion that we give. But what would that happen? Well, what would happen is that in the process, Indian lawyers would get an opportunity of sitting in India, doing whatever they want to do, being regulated by the Bar Council of India, being regulated by the New York Bar, being regulated by the English Bar Standards Board. It would be great for clients because all you have to do is come to India and find your one-stop shop. It would be great for the economy. It would be great for tax. So why is there a problem?
That's a perfect place to ask, why is there a problem? And let me just say, it's already been said here a little bit, this is not just a problem about India. This is happening all over the world. So again, I'm studying in Brazil. There's a big conflict going on in Brazil right now on this issue. China, which is probably more open to foreign lawyers than most other places, the Shanghai Bar Association is pushing back on various issues. It started really in Japan, where the first of the Asian tigers to develop. There was a big conflict around whether foreign lawyers could practice law in Japan. And it happens right here. I'm a Massachusetts lawyer. I cannot practice law in Connecticut. So forget globalization. How about nationalization, right? And for those who are law students here, I think they're keenly aware of this problem. So we see this over and over. The question I guess I want to ask of each of the panelists, but then we very quickly want to get other people involved, and I'm not going to call on, just because the additional solicitor of India is here, I'm not going to ask his opinion. Just teasing him, he knows I'm going to ask his opinion. But we've seen this story play out in other jurisdictions, most recently in Singapore. And actually, when we were upstairs, there was a very interesting discussion, which I'd like you guys to have a little bit here, about what you think of the Singapore model. So for those of you who are not familiar, Singapore's kind of gone through these steps. It started out basically banning foreign lawyers, then foreign lawyers could set up practices, but they couldn't have their actual name of their law firm. They had to have a name of the Singapore lawyers in the law firm, and they could only practice home country law, not domestic law. Then it was allowed to have joint ventures between Singapore firms and firms international firms coming in the market. And just recently, Singapore has now opened up its market altogether, and we see the same thing happening in Korea. I guess the question, Rajiv, I'll start with you, is what are the lessons to be learned from what's happening in Singapore for India? It's a place that there are lots of connections. You spend all three of you spend lots of time there. What do you think?
See, the Singapore model, I've personally spent a lot of time trying to understand the various models. Singapore decided to reform their own legal setup, I think which was about 97, 98, if I'm not wrong, around that time. And Prof is absolutely right, what he laid out, the steps. However, the one step where they really went wrong was where they allowed a joint venture firm and a Singapore firm to exist at the same time. So typically where there's an option, that is what really failed, the whole system failed because of that. And all the joint ventures, barring I think one odd, who were more gentlemen, or figure that out. They sort of survived, but everybody else collapsed. All of them broke because there were two firms allowed, the local firm and the joint venture firm. So typically in any system, so one of the lessons that we've learned, at least in India, we've advocated quite strongly that if we ever open up, it should be a single firm. It can be that the rights of audience to a foreign lawyer will not be permitted. That's a possibility. But they can partake in the profit of an Indian lawyer who's a partner in the firm. And to answer Nakul's when the two of them set up their practices and start working in India, you'll have to get around that structuring. You might need a commercial lawyer for that, I'm willing.
So, Nandan, what do you think about, because we know that the Society of Indian Law Firms has now said, actually reduced its opposition. We were just talking about Rajiv and that was somebody we all know very well, and that he sort of said they're now open to it, but they want a phased process. And my guess is this joint venture model is going to be one of the things that's going to be proposed. And I wonder how you think about that from your point of view.
Bad idea. I think it's a disaster, totally. You cannot force service providers, legal professionals, into a joint venture. Nakul wants to do a joint venture with me. We'll do it voluntarily,
Right.
not because regulations tell us to do that. And you know, just because Singapore did it or somebody else did it 20 years ago or 30 years ago doesn't mean that that's the model that India has to follow. You know, India, when I was growing up in India, it used to take 20, maybe a year to get a landline. And when India went through telecom reforms, it skipped through the entire generation of trying to introduce landlines, and they all have mobiles. And so today, India needs to skip through all the phases and increments that, or various twists and turns that other countries have gone through for reforming their legal sector, and get to the bottom line quickly. And what is that bottom line? And I'll nuance that statement a little bit. Again, I think India needs to really figure out what is this going to do for the country. And they need to create opportunities for all the young lawyers coming out of Indian law schools. Close to 250,000 a year, with 1.4 million lawyers in India right now. And this is simply part of creating opportunities for a lot of the young lawyers in India and outside India. The phase-wise progression, I can totally see that. Again, I think the Indian complaint that there is no level playing field for local Indian lawyers is a legitimate one. It's been there for 20 years, which is that they cannot advertise, they cannot have more than 20 partners, lots of difficulties. But hurry up and reform that quickly, please. I think that needs to happen very quickly. I do think that there are other steps that India may allow in the interim, like foreign legal consultant concept, which is if India is not ready to have foreign lawyers who are trained in non-Indian law schools, who are not familiar with Indian law, to come and practice Indian law, there is no reason why India cannot allow English lawyers or Singapore lawyers or New York lawyers to come to India to provide advice on those laws, New York, English, and Singapore laws, because the Indian government, Indian public sector units, and Indian private sector clients are soliciting that advice, except that they're having to go to London, Singapore, or New York to get that advice, making it much more expensive for the legal consumers. Ultimately, if India can eventually get to allowing foreign lawyers to practice Indian law with certain qualifications if they want to get to that, but I think there is probably a quicker way to get to something of a reform/liberalization without having to take this misstep of a joint venture in my mind.
So, Nakul, you know that there's been a lot of, one interim step has been that there should be liberalization only for commercial practice. And that the advocates bar, that there should be, in a way, a reversal of the 1961 Advocates Act, which said that there was one style of advocate for all purposes, and to divide the bar again between people who would appear, advocates who would appear in court and commercial lawyers. And I wonder what you think about that as a step.
Right. Professor, let me answer two questions. The first, which you in fact posed to Rajiv Luthra, which was Singapore and joint ventures, and that will then lead me on to answering your second question. How did I develop a Singapore practice? I developed a Singapore practice because after I got called to the bar, I needed work. And just because I got called to the bar didn't mean that people sent me work. And so if you get a foreign lawyer into India and he gets called to the Indian bar, doesn't mean that he's going to get work to go to courts. He's not. You've got to understand the Indian court system. You've got to have a level of familiarity with the procedure. You've got to have a level of familiarity with the law and with the judges. And only then do you start getting work. Now in Singapore, what happened with me was being part of a law firm and being a counsel with a law firm. I started getting pipeline work. I started going there. I started practicing. I started building a practice, which let me leave that law firm 5 years later, be accepted at the bar, and now be a part of an English barrister's chamber and get briefed by other law firms. So coming back to what will happen in India, it's very simple. If you decide to get called to the Indian bar, you would still need to build a practice and you would still need to understand procedure, because nobody would be a fool to get into court and not know what's going on. And I don't know if that answers your question.
I think it's a very important point. Law is both local and global. This is one of the complexities today. Law used to be the most local of all professions in the sense that the law was local, it was a personal service face-to-face, and now we know it's both local and global. In fact, we call it glocal, right, because it's global and local. But much has been said about what this means for India, and I warned him I was going to put him on the spot a little bit, and we're not asking him to tell us an official government position, although if he would like, we'd like to know that. But we do have the additional Solicitor General of India here. It's a great honor to have him in the audience in the panel. And just from your perspective of thinking about this from the perspective of India, right, separate and apart from what it means for Rajiv's firm or what it means for White and Case or what it means for particular advocates. How do you see this issue playing out? And I don't know, do we have a microphone?
No, that's all right. I'm used to it. No, first of all, my personal capacity, not the views of the government of India. Let's get that straight.
That is duly noted, sir.
Yes. I think opening up of markets in India or the foreign firms coming in, I haven't seen that kind of opposition ever from governments in India to this, as from the fraternity. And I think very often it's been a matter of perceptions in India, of mistrust, of creating impressions that as if law firms were to come in, it would take away jobs of people would be insecure, there would be a huge crash in the kind of clientele they'll all get usurped by the foreign firms. And to a large part, I think, the larger firms are to be blamed for that perception. I think it's the larger firms in India which have to a great extent fueled this distrust and perception in India. I think the average lawyer will in no way be impacted if the law firms were to come into India, because his nature of practice doesn't get affected at all. At a practical level, what Nakul rightly said, you've got to understand procedures, you've got to understand laws. So the bigger law firms for whom Nandan represents wouldn't really be interested in a small dispute in any case. So that completely goes out. So what are we looking at? We are looking at the bigger commercial disputes. Now who's affected by the bigger commercial dispute? The bigger law firms. And I think all these litigations, the perceptions which have been created over a period of time, pardon my saying so, and Rajiv is going to be very angry with me for that. He gave me dinner last night. I think a large part of it is the creation of law firms in India who have opposed the entry of other bigger law firms, because that brings in greater professionalism, that brings in greater competition, not just for law firms, for senior counsels, for average lawyers. And that's what we were discussing, David, that everyone cutting across will benefit if law firms were to come in. But yes, I think the law firms will also have to answer one question in India when they come in, which I think is a legitimate question asked in India about reciprocity. And that's a genuine question, that why should we open up when you're not willing to open up? That is a matter which law firms cutting across need to answer in India.
So I'm going to ask the panel if they have any reactions to that, but I also want you to be thinking of questions. I mean, again, we have lots of expertise, and I might call on Vic Khanna just because I know him well and we work together on the GLEE project. But any reactions to what the additional solicitor had to say?
I
Other
am
than that
angry
you're going to
with
read it.
I am very angry with you. But to be fair, I think Neeraj has very aptly put it, and like I said earlier on in my chat, that we'd like to definitely protect our turf. I'll be lying if I say anything different. Some of us have been more vocal, some of us have been less, but that's a fact. But there's also another flip to it. See, we are officers of the court. We shouldn't be playing cute with the law. We should be following the spirit and the letter. Now, as Nandan's firm understood at that time, it was purely legal to apply for a liaison office and open up, and which they did, and I was actually part of that process along with them. But there were some other law firms who opened a liaison office in India with 2 floors of a whole hotel as 48 lawyers working out of that hotel. And they got so blatant that they started billing with that hotel address. I mean, that's against the law. And also some other best friend, good friends, under the table friends, over the table friends, all these surrogate practices. I mean, as officers of the court, I just feel very bad that we don't follow the spirit of the law. We shouldn't at least be playing cute with ourselves. We can do that for them, but which I volunteered to do. But see, that's where the issue is. So distrust also comes from there. It's not so much see, there's also this view, and it was raised at one of the Bar Association meetings that I actually called for town halls over 2.5 years. I did this personally, and I met all of them. And one of them, they said, look, sir, if these English lawyers come into India, they will have only arbitration clauses, LCI in London. So all our filings will go out of India. This is the advocates and the arguing counsel saying. So, you know, there are many, there's some more sides to the court. But I think what Mr. Kaul has said is, I would say, 80% dead accurate.